It's not up to me to come to a determination about this flat. The fact that I think it had all of the charm and decorative je ne sais quoi of a Turkish prison is a matter for you. Particularly, Roger, as you rented this property for many years. You signed the first contract in 2009. You lived there till 2010, 11, 12, 13, 14, 15, many years. And so it's very difficult for me to come to a determination about what you did to that property and what damage was caused, perhaps, you say to me, by the flood. However, the situation is, in this case, that you signed a short hold tenancy agreement twice. You sign a contract, and in those circumstances, you have to pay your rent. That's your duty. Your rent comes in part from the council and part from you. At no stage whatsoever have you done that and performed your obligation of the contract. Now, that the house is in poor repair is a matter which has to be considered, and a matter which ordinarily I could take off whatever you owe. But in order to do that, you need to prove to me that damage caused to the property is their fault. Now, in respect of the rent, gentlemen, Hardep and Parminder, you're entitled to that rent of £3,272.84. However, you've got a problem, because I am satisfied that there was a leak in that property. I'm satisfied that it took place after the signing of the 2013 contract, and I'm also satisfied that any of the damages that happened to some of Roger's property happened as a result of that leak. Gentlemen, what you're not allowed to do in the circumstances is allow the flood to continue and say, well, I'm awfully sorry, Roger, take it up with the freeholder. You have to make good, because you've got responsibilities to him, obligations to protect his property, and in the event you lose money here and you think it's the freeholder's fault, you can take him to court, and I'm sure Judge Rinder would love to hear that case. Do you understand? So, I look at what the value of the claim is. On the one hand, you're claiming for rent £3,272.84, and I would give you that, but I have to take off any damage that's been caused as a result of the leak, which, in my judgment, you didn't properly repair. So I look firstly at the sofa and table, you get that. The TV, the clothes, £150. That was indeed a liberal guesstimate. Duvet and mattress, the cleaning implements. I'm going to be extremely kind to you, having looked at that picture of your flat, that there were ever cleaners there. And the computing equipment. You don't get the extra gas and electricity, I'm afraid, because I cannot come to an assessment of that without the relevant billing information. Adding all of that up, I take off £1,180 from what you owe. Therefore, this court awards you £2,092.84, which is a difference between what's owed for the damage and the rent that you're owed. When you rent property to someone, when you sublet it to them, you've got ongoing obligations to ensure that the house is in a decent state of repair. It doesn't stop just because you've got a freeholder. It's your responsibility. And I appreciate you've forgiven him many years' worth of back rent, but that doesn't mean that you can allow his property to continue in this state of disrepair. Get it fixed, and you've got to bring any problems regularly and timeously to their attention. Good Lord, this is like a Dickens case. Anyway, that's the award of this court.
Hardep and Parminder were awarded £2,092.84 of their claim after the judge took off the amount that Roger was owed for his counterclaim.